Thank you, Clerk, and good morning, members. To Fáilte Roa of Lig, we do have a quorum, and I now call the meeting of the Committee for Communities to order. I would like to welcome all members to this meeting of our committee. Can I remind anyone in the public gallery that mobile phones must be turned off? Mobile tablet devices can, however, be used through a Wi-Fi connection, and all devices should be muted. Password details are available in the gallery for anyone wanting to connect to the Assembly's Wi-Fi network. No recordings or photographs are to be taken. Can I remind members about the protocols regarding the use of electronic devices? Please switch all mobile devices to airplane mode and activate Wi-Fi connection. Please use tablet devices discreetly and in a way which does not interfere with proceedings, and be aware of cameras when using tablet devices. I would also like to remind members about the sensitivity of the microphones. And finally, I would remind members of your responsibility to declare any interest in any of the items under discussion today. So do any members have any interest to declare?
Chair, can I declare an interest in the private sector landlord?
Yep, thank you, Andy. And I also declare that same interest, that I also am a landlord. And Ciara?
I declare an interest in a family member in the construction industry.
Yep, thank you. Anything else, members? Just asking members to declare interest. Any other interest, members? No, thank you. Okay then, members, item 1 then is apologies. Clerk, can you advise if apologies?
Kelly Armstrong.
Kelly, yeah. No other apologies received. No, thank you. Okay then, Chairperson's business, members. After last week's meeting, I received a call from the Minister in relation to the Defective Premises Bill, which was introduced to the House on Monday. The Minister offered to meet with me and the Deputy Chair to try to get an understanding of any concerns that committee members had raised. Ciara and I met with the Minister on Tuesday. We raised with him concerns around accelerated passage and the absence of a committee stage for scrutiny. The Minister advised us that he is assured that the bill as introduced will provide an opportunity for people affected by defective premises, and his preferred position is that it should progress through the Assembly via accelerated passage. Indicative timings published yesterday indicate that the motion for accelerated passage and the second stage are both scheduled for Monday 3rd of June. On that basis, members, it is for the Minister to move the motion, which, if it is agreed by the House, would mean there is no committee stage. There is also correspondence in the pack pertaining to last week's evidence session from ISUA at agenda item 9. Should members wish to raise further, that will be coming up in correspondence. So, members, moving on to the draft minutes, I refer you to which are at page 6. There's our meeting on the 16th of May, and those are contained at page 6 of the meeting pack. Are members content to agree the meeting of 16th of May as drafted? Yep, thank you, members. Matters arising from those minutes, members, and there are a few. So you have been provided at page 14 with a reply from Ulster University on their report on housing affordability. The reply states that there has not been any similar work done since 2021, and this research was not updated by the university insofar as requesting more recent data on either mortgage arrears or indeed PRS rent arrears. Do members have any comments in relation to that item, or are they content to note? Yeah, thank you. Members, at page 15, there's a reply from the Minister for Infrastructure on wastewater challenges. That reply states that there is no doubt that NI Water faces many challenges, with more investment needed to both maintain what we already have and also to provide new infrastructure to keep pace with economic, societal and climate responsibilities. NI Water is committed to working with developers to consider ways of accommodating development wherever possible, and is encouraging early engagement with developers through the pre-development inquiry process. Do members have any comments, or are they content to note?
Noted, just in a comment, I mean, it's noteworthy that he says that in the current the last financial year, there was £500 million invested in water and sewage infrastructure. So that is a substantial investment. Actually, I didn't realise it was going to be that scale. So hopefully that means there is progress being made.
Yep. Okay, thank you, Brian. Members content to note otherwise, thank you. Members, at page 17 then, there's a reply from the Housing Executive on homelessness prevention and housing first. That reply states that the prioritisation of homelessness prevention is one of 3 objectives outlined in the Homelessness Strategy 2022 to 27. The development of a statutory duty in respect of homelessness prevention is a matter for the Department to take forward, and the Housing Executive is keen to support the Department in any work associated with the development of such a duty. The Housing Executive is committed to supporting the expansion of Housing First and has been represented on the DFC chaired Interdepartmental Task and Finish Group for scaling up the Housing First model for those at risk of homelessness. The Housing Executive has commissioned independent research on the feasibility study for Housing First for the North. Sian, do you have a comment you wish?
Yeah, I would just be really interested to hear a wee bit more about the Housing First feasibility study from the Housing Executive, just whether we can maybe have sight of some of their preliminary findings on that commissioned research, and I suppose how the Interdepartmental Task and Finish Group is feeding into that, and how just I suppose what potential challenges they foresee in that scaling up of the Housing First model. And it's really just to try and I suppose get ahead of, are there things that we can be looking at that can be put in place to support that that approach really.
Yeah. And we're content? We seek that information?
We're seeking oral briefing, written documentation.
If committee timings allow, I know that our forward work plan is cumbersome, but if it has to be a written briefing, I'm happy enough with that as well. But it would just be a wee bit more about that feasibility study.
Okay.
Thanks.
Any other comments, members, or are members otherwise content to note? Yep, thank you. Members, on page 19, a reply from Ofcom in relation to its role in gambling regulation. The reply states that as Ofcom does not regulate gambling in the UK more widely, they would not be best placed to brief the committee on this occasion. Members, we were seeking some reassurance about regulation of gambling activities here, so I wonder, do members have any thoughts on that, or would they be content maybe that we write to UK Gambling Commission asking them for an update on regulatory activities here? Because it would appear to be something of a under-regulated area at this point. Members content that we seek that?
Absolutely.
Yeah,
Okay,
thank
yeah.
you. So then moving on to, at page 20, there's a ministerial reply relating to the anti-poverty strategy. The reply states the anti-poverty strategy will ultimately belong to the Executive and all departments will contribute to its delivery in line with Executive and ministerial priorities. The response sets out that the Minister has been considering how best to take this work forward at pace and will shortly write to Executive colleagues setting out how he will continue to develop the anti-poverty strategy, including setting out a timetable. Any comments on members?
Yeah, sorry, it was just on the back of is EPOC, the end in paramilitary and criminal, that was in the pack last week. I feel like that is a really, that task and finish and cross-departmental working is a really interesting model that could actually be brought over into that anti-poverty field. And I'm wondering, is there any way of, I suppose, hearing, I'd love to bring in from, I know it was last week, but bringing in members from that. Adele Brown I met with and just was really interested in the methodology. That's the thing for me, it's the methodology and how that can be linked into looking at an anti-poverty strategy, because they are similar in their size in terms of the theme that they're looking at. And I wonder, would it be worth us looking at that as a learning for our anti-poverty approach? Because my worry is that the anti-poverty approach is going to be siloed, and at the minute, if that's an executive department and that's an executive document, my worry is how will everybody feed into that to actually be as effective as possible. We are already so far behind in our approach to this anti-poverty strategy, and that's my worry. Can we take learning from other projects of this scale that have already happened within civil service and across departmental kind of silos? So I suppose for me, there's a couple of things in there. Sorry, Chair.
Okay. We'll come back to them. I'll take Ciara, she is indicating there. Ciara, Lana Led Hull, go ahead.
Yeah, I'd just like to welcome, obviously, the Minister has reiterated that he's working at pace, but we haven't really received any new information from that response. So would it be possible maybe just to write to the Minister in relation to the anticipated timeline of how this is going to be worked through? Would be much appreciated, I think.
Yeah, thank you. And I suppose from my point of view, I agree with that. Certainly, to me, the Minister has to be championing it and really championing at the bit to get it onto the executive's radar. So I would be very keen to see the timeline as well, I have to say. And I'm just in my own head wondering, Sean, so a lot of this work has been done, the draft and everything sitting there, you know, do we risk almost starting to go back and looking at it again? Like, maybe should we signpost the minister or the department to that piece of work?
Yeah, that's great. I'm happy enough. I think it's more just, I would be interested in hearing how the learning from that, but that can be done outside the committee. That's grand.
Yeah, okay.
There is a briefing scheduled for next week, confidential briefing that the committee requested, an update on all the social strategies.
Yeah.
So there may be an opportunity to follow that up there.
Yeah. Okay, thank you, members. Moving on to page 22, there's a departmental reply to committee's queries on whether there were vacancies in the Universal Credit Migration Team and if this may be affecting payment timeliness. The response confirms that there are currently no vacancies in the Universal Credit Migration Team, and the data provided covers the period for the week commencing Monday 2nd of May 22 up to the week commencing 22nd of April 24. During this period, 79,093 previously made new applications to Universal Credit were due a payment, of which 77,381, 98%, received a payment on time, and 1,732, which is 2%, were not paid. These payments could not be issued because these claimants were unable to demonstrate they met Universal Credit's basic eligibility criteria. Do members have any comments, or are they content to note? So I think just I suppose the only comment I'd make is that there are quite a few difficulties with Universal Credit out in the street. So that 2%, I think it's important the department don't dismiss and provide some support to them to see what else they might what other criteria they might meet. But I think it's important to keep an eye on those people at the very margins who may just fall outside the criteria but still be struggling. So, members, also at page 24 then there's a departmental reply on thatched roofs. The reply states the department introduced the 12k cap to the HEF repair scheme in 2021-22 when the average cost of repairing a roof was 24k and the cap equated to support for repairing one side. It's the department's intention to revisit the cap for future work in 2025-26 and subject to available budget. In respect of technical specifications, the department is developing guidance for owners on the thatching of historic thatched roofs. It is also refining the detail required on specifications in its application form. So any comments, members, or content to note? Content to note, thank you. At page 25, members, there's a departmental reply on SL1, the Social Security State Pension Age Claimants. We had asked the department how the proposed statutory rule would affect couples in a household where one person is of pension age and the other is not. The reply states that the proposed legislation will facilitate the migration of mixed-age couples to either universal credit or pension credit, depending on their circumstances at the point of transfer. The reply further states that the aim is to provide a smooth transition to the benefit that is most appropriate to a claimant's present circumstances, either universal credit or pension credit, depending on their working status, and in line with the commitments given in respect of working age households, to ensure that eligible households do not see a reduction in benefit entitlement at the point of transfer, irrespective of which benefit they move to. Any comments, members, or content to note? Content, thank you. Content to note. And page 28, there's a departmental reply in relation to the correspondence committee sent to them asking about any work ongoing to plans for transposition of the European Commission's Pay Transparency Directive here into the North in line with the June 2026 timeline. The reply states that departmental officials are currently considering the paper alongside commissioned legal advice. Briefing and recommendations will be provided to the Minister in due course, and officials will keep the committee updated as the work progresses. Any comment or members content to note? Content, thank you. At page 30 then, there's a Department for Infrastructure reply on an anti-poverty strategy. The reply states the Minister is considering the Department's 2024-25 budget outcome and in taking decisions will be reflective of the wider societal impact. It outlines that officials in the Department were involved in development of the draft strategy, although there has been no engagement on the issue with the Minister for Communities. So any comments on that, members? I suppose the only comment, linking back to my previous comment, is the need for the Minister to champion this. So it would be important that, you know, if the executive are going to have, as he says, that key role, then it's important, I think, that those departments are being communicated with. So hopefully that's something that will be happening sooner rather than later. Otherwise, members content to note that? Thank you. So moving on, item then to agenda item 5, which is a departmental briefing on the pensions extension of automatic enrolment bill. The papers for this agenda item, members, start on your pack at page 33. I will now welcome the following officials to the meeting. So, good morning. So we have Hayley Ward, Head of State Pensions and Private Pensions Branch, and Richard Jordan, State Pensions and Private Pensions. So Hayley, I believe it's yourself that's going to give us an opening statement, a brief 5 to 10 minute statement, please, if possible, or as succinct as possible, and then we'll go to questions and answers from members. Thank you.
Thank you, Chair. Good morning, and thank you for the opportunity to attend committee today. We're very pleased to have the opportunity to speak to you today about the Pension Extension for Automatic Enrolment Bill, which from now on I'll refer to as the bill. We have provided the committee with fairly comprehensive written briefing on the bill. If the committee are content, I'll run through the background to the bill and the bill provisions themselves. So the Pension No. 2 Act Northern Ireland 2008, which I will now refer to as the 2008 Act, was passed by Northern Ireland Assembly and provided for the automatic enrolment into the workplace pensions in order to enable more people to save for their retirement and to make the saving the norm for most people in work. Automatic enrolment was then introduced here in 2012. The law requires all employers to enrol all eligible workers into a qualifying workplace pension scheme and pay pension contributions. Eligible workers are those who are not already in a workplace pension scheme, are between the ages of 22 and state pension age, and earn more than the minimum earnings threshold, which is £10,000 per year since 2015-16. In 2024-25, contributions are required to be made on earnings between the lower limit of the qualifying earnings band, which is 6,240, and the upper limit of the qualifying earnings band, which is £50,270. The minimum contribution rate is 8% of earnings. Of that 8%, employers contribute a minimum of 3% and employees 5%, part of which includes tax relief. Workers can opt out of automatic enrolment. However, every 3 years, an employer must re-enroll those eligible employees who exercise their opt-out of automatic enrolment with that employer. Again, employees can opt out at that stage. However, unless they opt out, employees will build up a private pension through their contributions and those of their employer. Since the introduction of automatic enrolment in 2012, saving for retirement has become the norm. In 2021, 73% of employees in Northern Ireland belong to a workplace pension scheme, up from 44% in 2013. In 2021, 72% of employees aged 22 to 29 in Northern Ireland were in a workplace pension. That's up from 25% in 2013. However, in 2021, only 17% of employees aged 17 to 21 in Northern Ireland were in a workplace pension. That was up from 1% in 2013. A statutory review of automatic enrolment was carried out in 2017 and found that young workers aged 18 to 21 currently miss out on automatic enrolment because the lower age limit is 22. The review also found that workers who earn more than £10,000 a year in a job are automatically enrolled, but because contributions are calculated from £6,240, the bottom of the qualifying earnings band, they miss out on a potentially significant contribution and possibly more than once if they have more than one job. The 2017 statutory review made 2 key recommendations: lower the age at which the qualifying workers are automatically enrolled into a workplace pension and reduce or repeal the lower limit of the earnings band. The measures contained in the bill arise from the recommendations made in the 2017 statutory review. Today we are bringing the committee the Pensions Extension of Automatic Enrolment Bill, which I will continue to refer to as the bill, to amend and extend existing powers conferred on the Department as provided by the 2008 Act. The bill will provide the Department the powers to lower the age at which qualifying workers are automatically enrolled in the workplace pension. current lower age limit is 22, and reduce or repeal the lower limit of the qualifying earnings band, so the contributions are calculated on more of a person's earnings. The proposals to extend automatic enrolment are intended to continue to normalise pension saving among workers, help lower earners build resilience for retirement, support individuals in multiple part-time jobs, and simplify automatic enrolment for employers. Workers will, as now, be able to opt out of automatic enrolment. The bill corresponds to the Pensions Extension of Automatic Enrolment Act 2013, which was enacted in Great Britain in September 2023. It is understood that subordinate legislation required to implement the changes to automatic enrolment in Great Britain will be in place so as to come into operation in the first few years of the next Parliament. The Department would seek to follow that timeline. Although pensions is a devolved matter, in general, pensions policy and legislation here operate in line with corresponding pension provision in Great Britain, in line with Section 87 of the Northern Ireland Act 1998. Many employers and private pension schemes operating in Northern Ireland are UK-wide. Therefore, it's highly desirable that the same provisions are in place in Northern Ireland to ensure parity across both jurisdictions. In accordance with its duty under Section 75 of the Northern Ireland Act 1998, it was considered that an Equality Impact Assessment, EQIA, was necessary and that the Department was required to consult on the EQIA. Whilst recognising it would be for an incoming minister and new executive to consider whether the bill should proceed, it was deemed prudent to consult on the draft EQIA during the period of interregnum. Accordingly, a draft EQIA on the proposals was published on the Department's website on the 18th of September 2023. And the public consultation on the draft EQIA then ran from the 18th of September 2023 to the 11th of December 2023. The EQIA considered the proposals in the context of their impact on groups set out in Section 75 of the Northern Ireland Act 1998. Those impacts were considered in light of available data and the policy intention in order to determine whether their effect was adverse. The EQIA found no adverse impacts on any of the Section 75 categories as a result of the proposals. 5 responses were received to the public consultation. The responses did not identify any adverse impacts to the Section 75 groups as a result of the proposals. Subsequently, the EQIA has been updated and finalised to reflect the outcome of the public consultation. Following ministerial approval, the EQIA final report was published on the 26th of April 2024. If the committee is content, I will now run through the clauses of the bill. So Clause 1, automatic enrolment, persons and earnings affected. Clause 1 amends the 2008 Act to insert 3 new regulation-making powers in Section 3, automatic enrolment, Section 5, automatic re-enrolment, and the new Section 13A, qualifying earnings reduction or removal of the lower limit. Subsection 2 inserts a regulation-making power into Section 3 of the 2008 Act, enabling the Department to amend Section 3, subsection 1, paragraph A, in order to decrease the age in which the employer has an obligation to automatically enrol job holders into a pension scheme. As I said earlier, workers will still be able to opt out of automatic enrolment as before. Subsection 3 inserts a regulation-making power into Section 5 of the 2008 Act to enable the Department to amend Section 5, subsection 1, paragraph A, and Section 5, subsection 1A, paragraph A, to decrease the age upon which an employer has the obligation to automatically enrol job holders into a pension scheme. Subsection 4 inserts a new Section 13A into the 2008 Act, which includes a regulation-making power to enable the Department to reduce or repeal the lower limit of the qualifying earnings band. It would also enable the Department to make regulations to repeal Section 9 of the 2008 Act, workers without qualifying earnings, necessary because this category would no longer be appropriate if the lower limit of the qualifying earnings band is abolished. Any regulations made under the new power in Section 13A may also include amendments, repeals or revocations to other acts as appear to the Department to be expedient in consequence of the repeal of Sections 9 and 13 and Section 13, subsection 1, paragraph A. Under subsection 5 of Clause 1, regulations made under any of the powers in the bill will be subject to the confirmatory resolution procedure. As regulations made under Clause 1 would amend primary legislation, it is considered appropriate for those regulations to be subject to the affirmative resolution procedure to allow Assembly scrutiny. Clause 2 is the commencement and short title. Clause 2, subsection 3 contains a standard power for the Department to bring Clause 1 into operation by statutory rule. As is usual with commencement provisions, statutory instruments made under Clause 2 are not subject to any Assembly procedure. It also provides the short title of the bill. We are happy to answer any questions that the committee may have. And thank you.
Okay, thank you, Hayley. So a couple from myself then, and I'll go to members then. Sean as well. So thank you for the briefing. And I just want to note it does seem fairly like a very positive thing that they've gone up from 25% up to 72%. So that's, I suppose, that's to be noted. The department has provided a draft bill and the EFM. Can you advise whether we can expect a delegated powers memorandum based on the extent of what is proposed in section 142?
That's in preparation, and you should have it very shortly indeed.
Okay, thank you. The other one for me then, so young people under 22, I suspect that one of the very last things they're thinking about is pension. So I'm wondering, what are the plans to communicate to make young people aware of that issue? And actually, I'm also struck by the fact that they actually now can be working quite a patchwork of jobs. Some of them, so this could be a very complicated area. So is there a dedicated communication plan going to be looked at to ensure that young people will know?
There is a plan in place. It's early days until the bill is fully through its legislative process. We can't move forward in that too quickly. We work in tandem with GB. They plan to have their subordinate in place this year. Given what's happened recently, that may be pushed back again. We'll work with them to create a proper, full communications plan. Yeah.
Just to add to that, so the early plans are we hope to communicate this through the usual advisory platforms, including dedicated government websites, press releases, and so on. And then we also have the Pension Advisory Service and the Money Helper, are free services across the UK that are tasked to ensure that people have free access to information and guidance. They need to make financial decisions, including pensions. And then employers must provide information about automatic enrolment to eligible employees, including their right to an employer contribution. The pensions regulator, which operates UK-wide, has a statutory duty to oversee and enforce compliance with employers' automatic enrolment duties.
Yeah, and that's all great, but I have to say probably the second last thing young people are thinking about is the dedicated government information website. That's probably, so I think we should be thinking about going where young people get their information from and make sure it fits that. Okay, I'll go to members. So I have Daniel, Brian, Sean and Ciara. Go ahead, Daniel.
Thank you, Chair. Thank you, Hayley and Richard, for being with us. Listen to your presentation. The financial implications of the bill for the public purse, employers and workers in the first year of implementation are set out on page 84 of our PACS members, which you have seen. And I was struck by some of the figures. So extra employer contributions of 0.8 billion, extra employee contributions of 0.9 billion, income tax relief of 0.2 billion. So considering the current problems we are facing in terms of finding the funding to finance public pay claims, what would this mean for the public sector going forward?
Well, at this time, the bill will not itself impose any costs on businesses or employees at this time. Subordinate legislation is going to be required in order to implement these changes. So the regulatory impact assessment has examined the impact of removing, and as you have said, you've read out the additional costs. So although the increased pension contributions so employer costs, how employers mitigate against the cost is uncertain, but most common approach appears to be that the employers will absorb additional costs with overheads and the effects of tax receipts, either on corporation tax, income tax, and national insurance contributions and VAT, or a combination of all of them. So, sorry, do you want to add anything to that?
I suppose The key thing to say is that this wouldn't have any impact on the public purse in Northern Ireland. There's no impact on manpower or private or public sector pensions. As Haley said, there may be impacts further down the line on tax take. That's a UK-wide HMT business. If you look at the increase in pension contributions, it works out, if you remove the lower limit, it works out as an increase of £9 a week to a typical employee's contribution pension plan. £4 of which is paid by the employee, a similar amount paid by the employer, and £1.20 paid in tax relief. So on a weekly basis per employee, it's a significant amount into their private pension pot, but it's hopefully a moderate cost increase to the employer.
Yeah, and I appreciate that answer, but from a Northern Irish context, from this assembly, particularly when it comes to public sector pay, that we're told, even for instance, classroom assistants, junior doctors, all key components of the ticking clock of our society, that there is no money. £4 a head per person from the employer, the government being the employer for each particular department. That will have a profound impact, I'm assuming, on the budget of those departments.
I mean, certainly there's other certain departments already automatically enrol public sector employees from 18 already. So there'll be some departments will already have that in place.
Okay.
So the impact may now, I don't obviously have that figure, and it's something that we maybe could look into, but it's not something. It may not be as big an issue as what it would seem for public sector, because an awful lot will already be enrolled in pension schemes.
It certainly shouldn't be an issue, but we're in Northern Ireland Assembly, and quite a lot of things that stem from this executive tend to be an issue that shouldn't be. So I think those figures would be helpful, just to see what the impact is on each department in terms of that extra financial cost. The other question, just subject to that, is, given that this will be absorbed by employers and it's a bill coming from Westminster, will there be will the Treasury resource any of these changes in any way? Any discussion in relation to that? No. In terms of how we are impacted in terms of the executive department.
I believe so, but I would have to. I'll have to have another check of that for you.
Okay, and final one, Chair. One of the intentions of the bill is to help lower wage earners build resilience for retirement, and you've articulated that in your opening remarks. What might that resilience actually look like, and are there any estimates of the potential benefits for those people?
Well, people who have saved more over their working life due to automatic enrolment will spend more on consumption in retirement than they would have otherwise. So this is expected in the long term to have a positive effect in the positive social welfare effect. We also, the regulatory impact assessment covers that, and so it is supposed to be positive, ongoing in retirement.
Okay, thank you, Daniel. Brian, please.
Okay, thank you, Chair. Thank you for the information. So far, I mean, certainly very much welcome the automatic enrolment and the extension of it. I mean, I remember in my own life, when this bill came in 2008, it meant I was able to start having a contribution to my own pension. Like a lot of people, I'd started the pension when I was a young man, single, and when I was married and had 3 young children, I stopped paying and just didn't have the finances, so I can understand how young people sometimes want to opt out, which I just couldn't afford contributions. So I remember when this came in, because of the employer's contribution in the job I was in, suddenly there was a payment going in, and so very much welcome that it's done automatically unless people opt out. I am always surprised when I talk to people and they say that they're opting out, but I know people just to do with their personal finances, but I always try to point out, look, your employer is putting in extra money, so you'll be quids up. If you enrol, there's extra money coming in to your lifetime income, but obviously it depends on people's own immediate circumstances. I welcome the EQIA no adverse impacts in Section 75 groups as a result of the proposals we identified, so that's positive. Daniel might have covered this point, but I just want to clarify again, when these changes come in, will the cost of this then be borne out of our departmental budgets, or will extra funding come from Treasury to cover it? So will it impact on, as I say, our departmental budget, or will there be extra money from Treasury?
I don't believe there's going to be any extra money from Treasury. It does look like it's going to be absorbed. What we should maybe note is that the public
Obviously, I'm
pension.
talking about civil service jobs.
Yes,
obviously.
I know, I understand that. So whenever automatic enrolment was brought in 2012, it obviously covered everybody from age 22 right up until state pension age. So that was a big change. We're talking about a relatively small amount of people. We're adding to this automatic enrolment the additional pension costs. It's a relatively small amount of people. So we did the age range at the moment in Northern Ireland, the age range between 18 and 21. There's an estimated 39,000 NI employees that may be eligible for automatic enrolment. And whenever I say may, these are the people that are earning over £10,000 and have been employed for over 3 months. So approximately 17% of this age range are already participating in pension saving. So the estimated potential additional workload across Northern Ireland is 32,000 people. So that's on relative terms. I know that sounds like a lot, but in relative terms, that's quite small compared to what we've brought in from 2012 to 2018, whenever we brought in automatic enrolment. What we need to remember too is the infrastructure is all there already for employers, including civil service. There's already the means for automatic enrolment, so the actual infrastructure should hopefully not be too burdensome on pension providers. Just extending it, but there will obviously be the additional costs.
Okay, thank you.
Thank you, Brian. Sean?
Thank you. Thanks very much for your briefing. As someone who previously worked with young people, I will echo what the Chair said. The chance of an 18-year-old or even a 17-year-old going onto a government website to find out about their pension is probably close to zero. I'd really like, and I know what you're saying about that communication plan not being able to be put into place until this travels through its legislative journey. I do think I would really encourage some kind of different communication plan. This has to be youth friendly. It has to be understandable by young people. And I think that it needs to feed into a much bigger piece of work that is actually encouraging young people to think about their futures and think about that, that it's never too soon to start saving for your pension. So that's my first. But I just want to get a wee bit of clarity. So in terms of, and I know others have talked about that employer contribution and the cost. On page 49, it's of our pack, the expected administrative savings for employers, and that it would reduce the administrative burden and cost. But then obviously on page 84, we're talking about a small additional business like administrative costs. I'm just confused as to, is this going to, we've talked about public sector workers, but in terms of even smaller businesses and SMEs and things, is this going to cost them more as per page 84, or are there going to be administrative savings as per page 49? I'm just a bit confused about that.
Yeah, so it's my understanding that during the 2017 review, the statutory review, employers welcome the change because at the moment they're having to segregate those workers as not being automatically enrolled. So it would be easier for them, for everybody to be automatically enrolled. Okay. So there is that additional admin cost at that point just to prevent those at that age being automatically enrolled. So the additional admin costs at this point is being projected as to include all of those people into automatic enrolment. There's going to be initial admin costs, initial changes in order to allow for those people to be automatically enrolled. So ongoing, there should be hopefully some savings, and that's what we have understood from the 2017 review. But initially, to get those people automatically enrolled, there will be some admin required.
So there are three cost streams. There's the additional cost of pension contributions that employees will have to make. There's the initial cost that employers will have to undergo to familiarise themselves with the new processes and procedures. And then there's the third cost, which is to do with processing additional people who wouldn't be automatically enrolled into the system. The benefit stream is that employers will no longer have to create this sectioned off group of staff who don't get AE because they're under a certain age. So there's trade-offs. It is slightly confusing, I have to admit, and it's early days in terms of cost-benefit analysis, but there's this balance to be struck there, I think.
Okay. Thanks.
Okay, thank you, Sean. Agus Jarnach Lanare Kira Lidahol. Go ahead, Kira.
Just thank you for the presentation. And I suppose I just want to come in on, I suppose, the communication aspect of it, because I know that's critically important and some of the members have raised it. And I suppose it's just more comment more than anything. The equality impact assessment, obviously there's some data that was missing for some of the Section 75 groups, particularly in relation to marital status and dependence, which obviously has a huge impact on someone's income. So it's just that. And then likewise, the responses, 5 responses, 1 email from the Housing Executive and 4 through Citizen Space. It's just a comment, and I've made this comment on numerous occasions with other departments. I think we need to be looking at how we can improve the communication or have additional methods of communication regarding an equality impact assessment. Because as part of an equality impact assessment, during that process, you're actually involving, you're engaging, and you're educating people on something. So that's just more comment. I just want to reiterate the fact that I think there needs to be other ways of effective communication, going out to our youth clubs, going out to our schools or organisations and engaging them, involving them in a process so they're getting educated that this is coming up rather than waiting, because I was just pretty disappointed that there was only 5 responses. So thank you.
Thank you. Before I come to Brian finally then, Hayley, just in terms of how it actually will work. So if a person opts out, will they automatically have been included and then they will have to wait to be excluded from the scheme, and how long is anticipated that will take?
So a person will be automatically enrolled and then they have an opt-out clause, so they can opt out, but the employer has to then re-enroll them every 3 years. And it's just, the main aim of that is to keep it in mind for employees that they can, you know, go back to their pension scheme. That's an option. We want to encourage people in order to save for their pension.
So, but they could be on for a number of months. So the contribution during that time, is that reimbursed, or does that sit in the pension and then it stops, or what's the practicalities?
Well, my understanding is it would sit in the pension scheme. Whether or not it could be
During there's a month-long opt-out period, during which time people can opt out and get their contributions back. After that point, if they decide to leave the scheme, because you can't opt out outside that 1 month period. Depends on the pension scheme rules. Usually you wouldn't get your money back if it sit in the pension scheme until you retired.
Yeah. Okay, and I think that speaks to even more importance of the communication if there's only a 1 month window. So, okay, thanks for clarifying, Brian.
Thank you, Chair. Again, just to come back to the issue of the additional cost to the public purse for those in the public sector. There's an adjustment to the lower qualifying earnings threshold, and then there's the reduction of the age from 22 down to 18. So those who are currently 18, they still have the option of opting in and receiving the employer's contribution. So it's just now they will be automatically enrolled unless they choose actively to opt out. I suppose there could still have been a cost for those that were 18 already. But with the lowering of the qualifying earnings, so the legislation in GB just came in last year, is that right?
the bill.
Yes.
The bill was enacted in September 2023, but there's been no subordinate yet, so they're not automatically enrolling their cohort of 18 to 21 yet.
I'm just wondering whether we can make a case, or whether we should be writing to the Finance Minister, just trying to put a figure on this or an estimate on this. You know, what is the additional cost to the public purse? I know you said potentially there be 32,000 extra people in Northern Ireland. That was public and private, I presume. But in terms of the public sector cost, can we put an estimate of the additional cost, and whether we can include that in our representations to Treasury? And I know we had some supplementary funding from Treasury announced earlier this week. So I don't know, is it possible to put a figure on it?
Well, Yes and no. It's very difficult because everybody has different earnings. So you really would be given a very approximate based on the range of salaries within the public sector. But you could certainly probably estimate the number of people that we may have in the public sector. But it's certainly something that we can definitely explore with Department of Finance. Either the department can do it or you can do it yourself.
Yeah. No, it might be something we take up with them.
I think Daniel had kind of asked for those figures. So if the department in the first instance gets them, then we can see what the
We can certainly look into it for you, yes.
if everyone's content with that. Yeah. Any other questions, then, members, or are we content? So just in light of the the complexity of all of that, I think we should ask the clerk to write to the examiner of statutory rules for a view on the powers referred to in the bill. So you can ask the clerk to that. Hayley and Richard, thank you very much for your information, and appreciate you coming to committee this morning. Thank you.
Thank you
And
very
good luck.
much.
Thank you. Okay, members, thank you. Moving on to agenda item 6, which is a departmental briefing on SL1, the smoke, heat and carbon monoxide alarms for private tenancies regulations. So the briefing paper for this, members, is contained there in your packs at page 89. I would now like to welcome to the meeting the following representatives. So we have Julie Lavery, who is head of private rented sector branch, Heather Cammock, a private rented sector, Donna Donnelly, private rented sector, and Audrey Fallon from the private rented sector. So you're all, to fault your row of a leg, you're all very welcome to this morning's committee meeting. Thank you for attending and for providing a statement. And I think, Julie, it is yourself maybe that we're going back to for initial short statement, and then we'll go to questions from members if needed.
Thank you, Chair, and thank you, members, for inviting us here today to talk about the Department's proposals to make the smoke, heat and carbon monoxide regulations Northern Ireland 2024. Many members will already have received the copy of the SL1 and the summary consultation report, so I'll just give a brief overview then of proposals. The primary power to bring forward these regulations is contained in Section 8 of the Private Tenancies Act, Northern Ireland 2022. The Act legislated to address the recommendations that came forward in the 2017 review of the private rented sector, and Section 8 is a health and safety provision which is aimed at reducing the risk of fire-related injury or death by bringing Northern Ireland in line with regulatory measures brought forward by other UK jurisdictions. Northern Ireland fire statistics for the 3-year period between 2020 and 23 show a total of 2,166 accidental dwelling fires, resulting in 29 deaths and 210 injuries requiring hospital treatment. The installation of a fire alarm system can substantially reduce the risk of death or serious injury, with fires detected more rapidly, less than 5 minutes after ignition. And the long-term downward trend in annual fire deaths and injuries is partly attributable to the increasing use of fire and smoke alarms in the home. The provision in Section 8 of the Private Tenancies Act is clear in the parameters of what the Department can specify in the minimum standards for alarm provision, and in summary, this is the number, type and condition of appliances that should be installed within private rented properties. As you may be aware from the consultation summary report, my team has availed of the assistance of an expert advisory panel to develop the regulations, and as might be expected, the Northern Ireland Fire and Rescue Service representative has been very much key to this work. So the proposed minimum standards are at least one smoke alarm installed in the room most frequently used for daytime living and in every circulation space, e.g. a hall or a landing on each storey, a heat alarm in every kitchen, and a carbon monoxide alarm in any room or circulation space which contains a fixed combustion appliance or flue. The regulations also detail the alarm type, which can either be battery or hardwired alarm, and the standards required. Easy read guidance has been produced to accompany the legislation, and a link will be placed within the explanatory note published on legislation.gov, and the guidance will also be actively advertised by the Department to private rented landlords, tenants and interested parties, for example, housing rights, once the legislation is made. I can confirm that all the necessary impact assessments were completed. The estimated financial impact on landlords was highlighted in the regulatory impact assessment and was drawn to the attention of stakeholders during the consultation period. That impact was assessed as not being overly onerous based on the relatively low cost of battery alarms and the evidence that many private rented properties already have some alarms in place, albeit not necessarily the full number are required or in all the right locations. As you may have noted, the regulations and associated guidance were subject to a 12-week consultation running from the 13th of September to the 6th of December 2023, and there were 64 responses to this consultation. Of these, 33 were from landlords, 2 from tenants, 10 from qualified electricians, 6 from local councils and 13 from other interested parties. The online consultation exercise was supplemented by face-to-face engagement sessions with key private rental stakeholders, including local councils, campaign groups, representative associations for both landlords and tenants, and representatives from the industry. No major issues emerged during the consultation that required substantive change to the regulations or guidance, and the main points that were raised with, and accepted with the agreement of the advisory panel related to the need for a longer lead-in time for compliance, and that's now set at 3 months for new tenancies and 6 months for existing tenancies after the operational date for the regulations, that there needs to be a carbon monoxide alarm installed in any room which a flue passes through, and that the guidance need to be revised to be clear on any cross-cutting building control requirements for hardwired alarms. And the regulations and guidance have been revised accordingly and have now been formally signed off by the Departmental Solicitor's Office. Enforcement action then will be undertaken by local council environmental health officers, and in light of that, our expert advisory panel included 2 officers as advisors to ensure the correct procedures are in place. All councils have met and set the penalty fine that non-compliance will attract in line with the Associated Department of Justice standard scale for fines and penalties, and the Northern Ireland Courts and Tribunal Service has not raised any issues in respect of court rules or the impact on the relevant court tier. I hope you find that overview useful, and we are of course happy to take any questions that you have.
Yeah. Thank you, Julie, and that's very clear and seems to be very comprehensive, so appreciate that information. I have questions in from Daniel and Brian at this point in time, and Sean. Daniel, go ahead.
Thank you, Chair, and thank you all for being with us. How does the statute rule compare with the requirements for a newly built house, and whether for a private individual or social housing development?
Donna, do you want to
Yeah. The statutory rules is that we can't, the change from the built regulations for new built property, that we're allowed to make the minimum standards, and we can have sealed battery alarms, where in a new build you need to have hardwired alarms.
Okay. And how does that compare with other jurisdictions? Is there any work in that, such as the south of this island or the rest of the UK?
We looked at other jurisdictions with the advice from our expert panel, the Northern Ireland Fire and Rescue Service. They advised us to look at Scotland's information. They actually do statutory guidance, so through legal advice we have to make regulations. So we looked at England and Wales, and the main information we took was, we took on board their what they had drafted, and we worked with the Northern Ireland Fire and Rescue Service, who was part of our expert panel representative, and we took on board information from them. Now the key differences is we did have a longer lead-in period, the 3 months and 6 months, as Julie had advised. We also, from the Fire Chief Council, we were also recommended to put a flue in, a carbon monoxide alarm in a room where there's a flue passing through, to provide more protection. Then also, if there's an open plan scenario, which means there's a living room and a kitchen, then we have made sure we regulated that a heat alarm, and that stops any other false alarms, with the smoke alarm being there. And the other one, if there's attached garage to the property and there's a fixed combustion appliance within the garage, then it must be a carbon monoxide alarm as well.
It certainly is robust, and I applaud the efforts that you have made, and they're certainly very welcome. Just a number of other slight technical questions. How will the statutory rule apply in multiple occupancy residences, for instance?
Well, the houses of multiple occupancy are covered under different legislation, and enforcement still sits with the Northern Ireland Fire and Rescue Service, and they were keen that we kept those regulations in place, and that they would be the enforcement body. So they sit outside these regulations, and they're still regulated under that other piece of legislation. and enforcement is by the fire service.
And Chair, two very brief questions. It is a very important piece of work. Wholly welcome it. But in terms of, for instance, the housing executive, what would the financial implications be if the statute rule on a body with significant property such as housing executive?
Well, this only covers private tenancy, so it doesn't cover social tenancy. So the housing executive wouldn't be affected by this legislation. But for a landlord, we did look at that about the cost, and we kind of took account of the cost of battery alarms. It's around £200, isn't it, for an average home. Now, if you were to move to hardwired, that would bring extra costs with an electrician, but you can then have the option of battery alarms.
Okay, and finally, are you confident that the process to ensure compliance with the statutory rule is robust, and will it be applied? Were you confident it will be applied firmly across all council areas?
Well, we have worked very, very closely with the council. Donna or Audrey, do you want to talk about the work with the council? I mean, they've sat in our advisory panel, and we have went and talked to the health and housing group extensively. But do you want to add a bit?
The stakeholders that we met, we had meetings with. A presentation was delivered to the environmental health officers throughout the 11 district councils throughout Northern Ireland, and the expert panel, as already was alluded to. There are 2 members of the council enforcement team within that panel. So we met with them and had open and up conversations with them. Also we met with the Landlords Association of Northern Ireland, and we actually attended one of their meetings, and we took minutes of face-to-face with them, and we spoke to them through the consultation and drafting stage. Also housing rights as well, we spoke with them as well, who have the renter's voice. They cover those, and several electrical bodies representing electricians to ensure that the installation and cost of alarms were covered. So there was a lot of extensive discussions made with outside bodies.
So the regulations really have been co-produced. I mean, we did look at other jurisdictions, but we very much took account of the Northern Ireland circumstances and really co-produced them with those stakeholders. And councils were very much involved in, even when we were drafting the regulations, sitting in with us as we were drafting. It
certainly sounds like a great piece of work, and your efforts are to be applauded. I certainly welcome the changes that are proposed, and hopefully they all bear fruit and save lives ultimately, which is what it's about. So, well done.
Yeah, just before we go to Brian, a wee follow-up to Daniel's, because I thought that was an interesting point there. So are the housing executive and the housing association already at that standard, or are there plans in place to bring them up if they will now be lagging behind? Are there plans in place to bring them up?
The housing executive actually responded to our consultation, and they confirmed that they welcomed the piece of work, and they're going to try and replicate it as well.
They actually have their standards. It was 10 years, and they're going to putting it in line with ours to 5 years checks as well.
Okay.
But in their sector it'll be voluntary, in this sector it'll be mandatory. Do you not think that's maybe something that we should?
We can certainly go back and check that. I'm sorry, Chair, I don't know offhand the standard for social housing. I'm sorry, I should have looked at that before I came today. But we can certainly go back, and we'll come back to you on that.
If it's important in the sector, and it is,
yeah.
I agree it is.
Yeah.
I think it's important across the board. Brian.
Thank you, Chair. And yes, this is very welcome bill and increase in safety regulations. So my question is just about, in terms of councils, environmental health departments enforcing this, does the bill set out arrangements for that, or is it up to each council? I note there it talks about at the start of every tenancy and so on, but are councils required to carry out inspections, or if a tenant feels the alarms are not up to standard, obviously they could take a complaint, but I'm aware quite often tenants feel quite vulnerable, with the high demand for private rentals, and might be nervous about annoying their landlord, but they have the right, obviously, to the appropriate safety and standard of properties. So what onus is there on councils not just to wait for a complaint, but actually to carry out some proactive inspections or checking, especially given that alarms have a lifespan too?
Yeah. Well, councils are the enforcement body for the majority of private tenancies legislation. It does set out what action councils can take. But Donna, do you have the details there to add on exactly what?
Just working with the expert panel, the two council representatives nearly on a weekly basis with these regulations, they confirmed if they go out to the property for anything, they'll do a full check. So although it is counteractive, it's really if a tenant reports the issue, the council, if they're going out for any other issue, they'll make sure the property meets required standards for across the board and not just the smoke alarm.
And I suppose maybe just to add to that, we are carrying out work to transfer landlord registration to councils and to try and make that landlord registration, the register, a more useful tool for landlords to, or for councils to use for enforcement action. So that's ongoing in the background as well.
So is the checking just a visual check, or do landlords have to submit a form clarifying that they have these alarms in place and at the date in which they're installed? Is that done as a matter of routine?
As part of the new IT system for landlord registration, they will be able to check then that they've complied with the new electrical safety and that's coming in and alarms. Do you want to add something?
We've also added into a tenancy information notice to ask, and that was part of consultation, the tenant or landlord should be supplying the tenant with a checklist of everything that's up to date in the property and what standards they're meeting, and they should retain a copy of it. Now, that's not within the regulations, but it's recommended within the associated guidance notes.
No, I think it's important that it is listed and the landlord has to proactively indicate that it is up to standard.
Yeah.
Okay, thank you.
Thank you, Brian. Sean?
Thank you. Yeah, and thanks so much. A lot of my questions have been answered. So the one that is left is just around the communication strategy and how that is going to be communicated both to tenants and to landlords of their responsibilities and their what standards they have to be. And I suppose for me, especially for those who own multiple properties, just how is that going to be communicated to both landlords and to tenants?
We have done a lot of work around consultation and we have a communication strategy in place to try and reach people. Or do you have been involved in the comms piece? Do you want to add a bit of detail on the comms?
As soon as we get the go-ahead, then I'll be able to go to publishing the summary report and then all the tweets and stuff like that that'll come thereafter. But, you know, I will be sending out letters to, I've had a lot of people, stakeholders. There'll be letters sent out to all the landlords registered, to all the comms team. They'll be working closely with me afterwards, so that's what we will be releasing with our communication team in the press office. They've been involved in assisting and getting the approach right, and the communication will continue to be ramped up. So the point then will be after this, advertising the publishing of the summary report and then highlighting when landlords need to take action to comply and what the compliance dates will be, and then further down the line communicating again at the 3-month and the 6-month for the new and the old existing tenancies. The properties will now need to have the right number and type of alarms in place, so that will all be in hand as soon as we get the green light.
And there's also companies advertising, I think they're advertising in Cool FM and things like that about, you know, the need for alarms and things like that. So they've actually went before us with their advertising campaign, but it is getting quite a lot of traction.
Yeah.
You know,
I think just feeds into a bigger piece of how we communicate the rights of tenants and what they should be looking for when they enter into new tenancy. But then also, if you have the responsibility of being a landlord, here's exactly, you know, what you have to be following through. But thank you so much. That sounds like there's been a lot of bases covered and a lot of work. But thank you.
Thank you, Sean. And then Ciara, sorry, go ahead, Little Hall.
I suppose the questions have been asked that I was going to cover. All I just want to say is just to commend each and every one of you. I think it's a fantastic piece of work.
It is.
And that's really all. I think the intensive engagement that you've had kind of is reflected on the actual regulations now coming forward. So that's really all for me, really. And particularly, I suppose, it's just that communication piece again and enrolling it out and ensuring residents. We're well aware, like 19% of our housing supply is in the private rented sector. We have some excellent landlords, and they can be informed and engaged. I welcome it's going to be in the guidance in relation to landlords informing the tenants. So I suppose it's both just reiterating the fact of utilising those consultees, the likes of Housing Rights and LANI, etc., of how residents can be informed and engaged. There is mechanisms there. So, no, thank you.
Okay, thank you. Members, any further questions for the panel? Okay, well, listen, thank you for that briefing this morning. That's very, very helpful, and good luck with it all. Thank you very much. Members, now having been briefed on the proposal, can I ask if you are content for the department to proceed to make this rule?
Content.
Yeah, members content. Members, we are now going into closed session to receive a confidential briefing from Assembly Legal Services. So I'd like to request closed.
So just to say, Maurice Bradley has communicated his apologies to me for the meeting. That can be added into apologies. Yeah.
Okay, so if I could ask clerk to bring us into closed, and it'll
Received confirmation, Chair, sorry. That's open now.
Okay, members, thank you. So we're resuming then at item 8. And just to advise members, that has not been received, so the department hasn't moved at this stage. So moving on to agenda item 9, which is correspondence. So we refer members to the correspondence memo at page 145 of your meeting packs. And there are a couple of items I would welcome a committee view or decision on. The first is at page 226, and that is a request from Ulster Rugby to brief the committee. Are members content to receive a briefing at a future meeting? Yeah.
Sure, can I just ask, will that fit into the engagement event that we're looking to do with sports organisations?
Potentially, yeah.
Or does that need to be separate?
Well, no, I think, and I was going to suggest that we do make a sports focus. Use that as a sports focus. I think it's maybe useful. So yeah, I think that's so. Members are content, clerk. Yeah. The other item, correspondence then for decisions, page 371, which is an email in relation to our meeting last week and the briefing by RSUA on the defective premises bill. Members are proposed we send a response to this correspondence stating that RSUA had written to the committee requesting the opportunity to brief the committee in relation to concerns about the forthcoming legislation. Are members content? Thank you, members. I also, members, draw your attention to the budget paper received in the table pack at page 69. The clerk's summary memo at page 64 to 68. Members, unfortunately, I do have to express concern at this stage in the session. There's a budget debate scheduled for next Tuesday, 28th in the House, a debate which statutory committee chairs will be invited to outline the committee's views on the departmental allocations, and yet this committee still has not received any detail or briefing on the 2024-25 budget. I note that we have requested an update on the budget and that it is marked TBC on the forward work programme. So, clerk, has a date been confirmed for that yet?
We're holding a space at next week's, the last week in May and the first week in June, still TBC.
Okay, so members, the role of the committee is to undertake scrutiny, and it's a key aspect of that is budget scrutiny, following the money and the department's prioritisation of same and decision making in relation to it. So, do any other members wish to make comment in relation to that? Sian?
I'm just trying. Sorry, I had up the my issue, Chair, was that even when we get the top line figures here, it's nearly impossible to compare on last year, because whenever you go to last year's document, which although it wasn't put forward from the Minister, it was from the Permanent Secretary because of the state that we were in, they're not the same headline figures, so it's actually impossible to compare like for like, to actually see where those pressures exist, how where I suppose reductions or cuts have been taking place. I found that really difficult, so I couldn't even have a top line understanding of where the pressures were coming when I saw the figures, because they're not like for like.
I wonder, can the department address that to provide?
I can follow up again. I have asked for as much indication as we can have so that members can take part in the debate. So I will chase that again.
Thank you, Sian. Anything else, members? Okay, thank you, members. Do members then have any other comments in relation to any of the other items of correspondence in pages 145 to 381 of your original pack, and then from page 57 in the table pack? Any other comment, members, or issues? Or are members otherwise content to action the correspondence as outlined in the memos? Yep. Great. Thank you, members. Item 10, forward work programme. Members, which you will find the updated forward work programme in the pack at page 384. Do members have any comments, or are they content to note the forward work programme at this stage? Intent to note. Thank you, members. Agenda item 11, members. Any other business? Do members have any other business today? No. Thank you, members. Item 12 then, members, is date, time and location of the next meeting. Our next meeting will be at 10 a.m. on Thursday, 30th of May 2024 in room 29 here in Parliament Buildings. The meeting is now adjourned, and I'd like to thank all members today and all of the committee staff for the preparation for the meeting. Thank you all and good luck.
you.
Committee Room 29. Sound.